Okay, thank you.
All right, the juror in seat 31, please.
231.
31? Sorry.
31, please.
Good morning.
Good morning.
We have a few questions for you. I'll go first, then the lawyers. Let me tell you that there aren't any right or wrong answers to these questions. There's just the truth.
Yep.
We need to know what your beliefs actually are and how you feel about things. So don't worry about the answer. Just answer the question that we're asking you. Let me start with, you indicated that you'd heard something about this case. Can you tell me where and when you heard it?
You know, I think when it originally happened, through the media, through the news.
Did you hear it on TV, read about it in the paper, the internet?
Probably both.
Both?
Yeah.
Any Facebook or Instagram things that you saw that you can recall?
I don't believe so. Mostly through TV and
Do you
newspaper.
pretty regularly consume the local news, watch it?
From time to time, yes.
Okay. And at the time that you were watching this or reading about it, did you talk to anyone, like family, friends, coworkers?
Not that I can remember.
Okay.
Yeah.
Can you tell me what it is that you remember hearing about it?
Well, I think I remember when it happened. You know, about the shooting at Walmart. At the time, I believe we were living in Maitland or College Park. I can't remember. So it was relatively, you know, closer than not. So, yeah, I mean, I remember seeing it, you know, on the news the day that it happened.
Okay.
Yep.
Do you remember seeing it after that?
Yes.
And what do you recall seeing?
I mean, nothing in particular. Just, I mean, I would see the just as the incident, you know, moved on. I mean, I just remember hearing about it from time to time.
Okay.
Mm-hmm.
Anything that you heard jump out at you?
Obviously, it was a terrible incident.
You what?
I said, obviously, it was a terrible incident. So, yeah.
Did you form any opinion about whether or not Mr. Loyd was guilty at that time?
I would say probably yes.
Okay, and what was that opinion?
I mean, it appeared that he did do it based on what I saw on the news.
Okay. So jurors have to be able to presume Mr. Loyd to be innocent until and if the state can prove he's guilty. Do you think that you could do that?
Yes.
Okay. So let me give you three scenarios, and you tell me what, if any of these apply to you, okay?
Sure.
Number one is he's innocent. The state needs to prove to me he's guilty. You're sitting as a juror, okay? I forgot to tell you that part.
Yep.
State needs to prove to me he's guilty. Doesn't matter what I saw on TV. Number two is, you know, I saw all that stuff on TV. He's probably guilty, but I'm willing to see if the state can prove it. And number three is, I think he's guilty, but I'm willing to see if I'm wrong. Do any of those three apply to you?
I would say probably the second.
That he's probably guilty, but you're willing to see if he's not?
Yeah.
All right, thank you, sir. State?
We move, Your Honor.
Any objections?
No objection.
All right, thank you, sir. Unfortunately, when folks see a lot about cases,
Yeah.
they can't meet the standard, so we appreciate your time and your coming in today. I'm going to excuse you as a juror in this case. This is juror in seat 31. You're juror 474, right?
Correct.
All right, I'm excusing you as a juror in this case. You are free to get on with your life. Thank you so much for your time. All right, thanks. All right, juror in seat 32, please. Good morning, sir. How are you?
Fine.
You're juror 167?
Yes, ma'am.
All right. I'm going to be asking you some questions, and then the attorneys get a chance to ask you questions. It's very important that you just answer the question truthfully and fully. Don't worry about what the answer is. There aren't any right or wrong answers. We're not actually looking for a specific answer. We just really need to know what you think and what you believe, okay?
Okay.
You indicated to me that you had heard something about this case. Can you tell me what you heard?
Well, basically the news coverage when it was back. When
it happened?
Yeah, it happened.
Do you watch the local news a lot?
Yes, me and my wife watch at 10, 11, whatever time before we go to bed.
How much of it did you watch of the coverage?
I mean, just what they covered on the actual news. That's pretty much it.
What do you remember seeing?
Just the whole process of him, being hunted, and the media saying about what had happened in the case and them going through the proceedings. And I didn't really watch much of the trial coverage.
Okay. You mean the first trial?
Yeah.
Okay. Did you watch some of it?
Just the highlights, I guess you can say.
Just whatever they showed.
Yeah, whatever they splashed on.
So throughout the years since it happened to now, till you came to this courtroom and I told you stop watching the news, did you occasionally see stories about this?
I think the last time it was last week when they just kind of snipped about it.
Okay.
It wasn't, just brought it back into the light of the whole thing.
And at the time this was all going on, did you talk to family and friends or coworkers about this?
Not really, just my wife. That's pretty much the only person I spoke to about it.
Did you have an opinion at that time as to whether or not Mr. Loyd was guilty?
I didn't really form any opinion, but, I'm the type of person, I kind of watch news and then I don't. I'm more of a sports junkie, so it's kind of that's my mentality.
All right, so in order to sit as a juror in any criminal case, you have to be able to presume Mr. Loyd is innocent until and if the state can prove he's guilty beyond a reasonable doubt.
Yes, ma'am.
Can you do that?
Yes.
Do you have any doubts, as you sit here now, that if you were picked for this jury, you could presume him to be innocent and hold the state to their burden?
Yes, I could do that.
Okay. Do you have any religious, moral, or personal objections to the death penalty?
No, I don't.
As I told you before, the only cases where the death penalty is even possible, it's first-degree murder, which is premeditated murder of another individual. You have to intend to kill the person. You understand that?
Mm-hmm.
Is that a yes?
Yes, I'm sorry.
Okay, no problem. There is no automatic death penalty in the state of Florida. The automatic sentence for first-degree murder is life without the possibility of parole, unless it falls into this special category where the state can prove at least one aggravator beyond a reasonable doubt. Then death becomes a possibility. You follow me so far?
Yes, I do.
Okay. So a couple of questions for you. Is there this case involves a law enforcement officer. So is there anything about that would cause you to automatically vote for death if Mr. Loyd was convicted of first-degree murder?
No, it wouldn't.
Is there any type of case, not a specific case, but type of case, where you believe that death should be the automatic sentence if someone is convicted of first-degree murder?
No, I don't.
You heard me describe the process of what you have to do. Go back, listen to the aggravators, listen to the mitigators. Unless the state proves at least one aggravator beyond a reasonable doubt, you can't even consider death. You understand that?
Yes.
But assuming that had happened and the defense has presented their mitigators, number one, can you sit in this courtroom and listen to all of that with an open mind for both sides?
Yes, I can.
All right. And then can you go back in that jury room and weigh aggravators and mitigators? And by weighing, I mean each juror gets to assign whatever importance they believe, for you personally, whatever importance that aggravator or that mitigator has. You have to weigh all of that. And at the end, you have to come to a decision as to whether or not you believe life or death is the appropriate sentence. If all of that led you to believe that life without parole was appropriate, could you vote for that?
Yes, I could.
And if all of that led you to believe that death was the appropriate sentence, could you vote for that?
Yes, I could.
All right. Moving on to the insanity defense. You heard me tell you, Mr. Lloyd's raised the defense of not guilty by reason of insanity. This is in the guilt phase when you're trying to decide whether or not he's guilty of the charges. All right. And the burden, this is the only time in the guilt phase, the burden's on the defense to prove this. The state doesn't have to prove it. The defense does by clear and convincing evidence. So if at the end of the guilt phase you felt that they had proved it, could you return a verdict of not guilty by reason of insanity?
Yes, I could if
right.
that was the case.
And last question. You heard me tell you that he's been convicted of the murder of Miss Dixon and her unborn child and sentenced to life without parole. You can't use that to decide whether or not he's guilty of these charges. It's a different case. You understand that?
Yes, I do.
Do you believe that you would be able to put that completely out of your mind in the guilt phase and determine whether or not he's guilty of these charges based solely on what you hear in this courtroom?
Yes, I could.
All right. Thank you, sir. I don't have any other questions for you, but I'm going to turn it over to the state. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
So I want to go back to your watching the news. Did you see any of the news coverage about when Mr. Lloyd was eventually arrested for the murder of Lieutenant Clayton?
Yes, I did.
All right, what did you see about that?
Pretty much when the whole thing started, from them showing her and him in the Walmart, I guess, so to
Okay.
speak, and the chase after, that he had fled, and then kind of that was about where it left off.
Did you see any video from the night where he was apprehended or arrested?
I did see where he was arrested and they showed him in court being arraigned,
Okay.
and,
What about specifically from the night where law enforcement found where he was and arrested him? Did you see any video from that helicopter footage?
yeah, a little bit, not a lot.
What do you remember being depicted in the helicopter footage?
Just them pretty much chasing him and showing the night vision things of that nature, and then pretty much that's about it, really.
Do you know whether or not Mr. Lloyd sustained any injuries as a result of the arrest?
I didn't see any other than when he appeared in court for arraignment that his face had been scarred, had stitches and whatnot.
And based upon what you saw, was it your understanding that those injuries came from law enforcement when he was arrested?
Again, I can't say yes to that. I don't, I didn't see the actual arrest or any of that, so it's hard to describe how he got him, so I can't say yes or no.
Okay, have you heard any descriptions about how he got them or the circumstances surrounding his injuries?
Not really, because
No?
like I said, I didn't really watch a lot of the coverage, just what was mainstream on the news at the time.
Okay.
I'll be honest with you, most of the time I fall asleep when I'm watching TV because it gets late. And,
Waiting for the game to go into overtime?
Well, I work, I get up real early, and by the time I get out of work for the long period of time, I'm usually by 9:30, 10 o'clock, I'm kind of zoning out, so I'll catch maybe the first half hour, and then I'm out, and then I just go up to bed.
Okay. One moment. May I have a moment, Your Honor?
Yes, sir.
All right, sir. So we have a questionnaire that you filled out with some basic information. And on that questionnaire, it indicates that you were previously a juror.
Yes.
How long ago was that?
Oh, good. Quite a while. It was a civil case.
Okay.
Just,
So you've been a juror one previous time?
yeah.
And it was a civil case?
Mm-hmm.
Is that a yes?
Yes, I'm sorry.
That's okay. It happens to all of us. Was that here in Orange County?
Yes, it was.
And without telling us what the verdict was, did you reach a verdict?
Yes, we did.
Were you the foreperson?
No, I wasn't.
Okay. Anything about that experience that you think was unpleasant or makes you not want to be a juror in this case?
No, not at all.
Did you enjoy it?
I won't say it was a great time, but I didn't have a problem with it. I was fine with it.
Fair enough. So the judge asked you if you had any moral objections to the death penalty, and she said no. But could you just give me, you said no. Could you just give me your general feelings about the death penalty as a concept? What you think about the fact that our state has the potential sentence of death if you commit a certain type of first-degree murder?
I mean, it's hard to explain. I mean, my feeling is that sometimes mitigating circumstances call for certain things to happen, and if the case presents itself and the evidence and everything that I would see, I mean, I could have no ill will feelings towards that death penalty, but I mean, I don't have a real moral stance on it. I'm a religious person. I'm a Catholic, but I don't know. It's hard to explain. It's not something I take lightly, but I'd have to really see everything, the whole picture.
My understanding is that the general belief of the Catholic Church is that it's opposed to the death penalty. Given that you're Catholic, it sounds like you don't subscribe to that portion of it?
Not really. I mean...
Enough. Would you agree that you believe that the death penalty is potentially appropriate in some circumstances, but not all?
Yes.
Is that fair? Is that
it's a fair assumption, yes.
Okay. All right. You also indicated on your questionnaire that you have close friends or are related to members of law enforcement?
Yes, I mean, I play softball, so I'm around a lot of guys that are law enforcement. My Monday night team, 2 of the guys that I play with, they're law enforcement.
Okay. So, do you know what agency they work for?
I believe one works for Orange County. I'm not 100% sure. I just kind of started playing with these guys. It's kind of a core of guys that I know, and the guys that are the 2 law enforcement. I've seen them. I play against them in what we call a half-century softball tournaments.
Based on your age?
Yeah.
Okay, just making sure.
No, it's 50 and over tournaments that we play all over the state of Florida.
Okay. Well, you've obviously been told that the victim in this case is a law enforcement officer.
Yes.
Anything about your relationship or playing softball with those 2 officers, or your thoughts on law enforcement generally, that you think would prevent you from being fair and impartial in this case, given that the victim is a law enforcement officer?
No, I mean, I appreciate and respect law enforcement and all that they do and what they have to go through. But I don't think it would sway any decisions whether that's the fact. I look at it as a person, not whether they're wearing a uniform or not.
Okay, understood. So, if and only if Mr. Loyd is convicted of first-degree murder, then your next role as a potential juror would be to render a verdict on what the actual sentence should be. Does that make sense?
Yes.
And I'm talking about the second phase now that the judge had described.
Yes.
Did what she described to you make sense to you?
Yes, it did.
Do you understand, or do you feel like you understand what your role would be? Because if you don't, let us know, and it's okay, because it's complicated.
Yeah, I mean, I get the gist of it. It's not 100%, but...
All right, well then, I'm going to walk through a little bit of it,
Okay.
just so I can make sure that I understand how you feel. So if Mr. Loyd were convicted of first-degree murder, we would have the obligation to present evidence of aggravating factors. And those are things that are defined by the legislature that make, in the legislature's opinion, a first-degree murder above and beyond one that lacks those aggravators. I'll give you an example not related to this case. One aggravator in the state of Florida is that the victim was a child under the age of 12. Right? Can you appreciate why that's an aggravator?
Yes, yes.
Right. So it's things like that, and it's things about how the crime was committed, or maybe sensitivities of the victim. We have to prove at least one of those beyond a reasonable doubt. Right? If all the jurors unanimously determine that we have proven at least one aggravator beyond a reasonable doubt, the next thing that you all would be asked to do would be to find which mitigating circumstances you believe were proven. Okay? Mitigating circumstances are things that the defense will present evidence to you about, and those are anything about Mr. Loyd's life, background, or character. Anything in his life or background or character that they believe are reasons why a sentence of life in prison without the possibility of parole is more appropriate than death. Does that make sense?
Yes, it does.
Right? So you would listen to those, and then at the end of that, if you found an aggravator was proven, you would weigh the aggravating factors against the mitigating circumstances that you believed were proven. Make sense?
Yes.
Right? And their burden is lower to prove mitigating circumstances. So you decide as a juror how much weight, how important you think any given fact is. That goes to the aggravators that are proven and to the mitigators that you believe are proven. Make sense?
Yes.
And then at the end of, when you consider how much weight you're going to give them, you would determine if the aggravators outweigh the mitigators or if mitigators outweigh the aggravators. If and only if the aggravators outweigh the mitigating circumstances, then you would be authorized at that point to render a verdict of, or your recommendation of death, or your verdict of death. I apologize, your verdict of death. Make sense?
Yes, yes.
Does that process, is it sensical and logical to you?
Yes.
Right. So the key component of all that is you have to be able to give meaningful consideration to everything you hear. Does that make sense?
Yes.
So even if you heard aggravating factors that you found were persuasive, you would still need to be able to give meaningful consideration to any mitigation that the defense presented about Mr. Loyd. Could you do that?
Yes, I could.
Any concerns about your ability to do that?
No.
Would you be open to doing that before rendering any decision in the case as to the sentence?
No, I can. Yeah, I can do that.
If you believed that, well, I'm backing up a moment, understanding that you would need to give the mitigating circumstances consideration, even if a first-degree murder has been proven. In other words, that an individual murdered and killed someone else, they did it, they premeditated, they wanted to do it, there was no defense. Even in those circumstances, you would need to consider the mitigating circumstances. Are you sure you could do that?
Yes, I could.
Okay. Would you want to hear the information that the defense presented? Would it be important to you?
Yes, I mean, all the facts. I need to hear everything to render a good decision. I don't believe that it should be one-sided. I mean, in general.
All right. If you found that we didn't prove an aggravator, or if you believe the mitigating circumstances outweighed the aggravating factors, could you vote to impose a sentence of life life in prison without the possibility of parole?
Yes, I could.
Right. Conversely, if you believe the aggravators outweighed the mitigators, and you thought it was appropriate under the circumstances, could you vote to impose a sentence of death on another human being?
Yes.
You could. Right. As you sit here now, are you leaning either way as to either potential sentence if Mr. Loyd were convicted of murder?
No.
Anything about that process that you think would present difficulty for you, other than, of course, it's an important decision?
No, I mean, I have all the facts laid out in front of me, and I would make my decision rendered on versus, the mitigators and the aggravators.
Okay.
It's just something that I believe that everybody deserves,
a fair
trial.
Yes, sir.
Because in my mind, I think you put yourself in somebody else's shoes, even though you don't know what circumstances create certain things, but give the benefit of the doubt for everything. I'm kind of that person, I believe in.
Given that the defense of insanity is a potential issue in this case, have you or anyone close to you ever dealt with mental illness that you're aware of?
No, not really.
Right? There are those in our society who say that mental illness is made up, it is a false justification, attempt to get away with stuff. Do you believe that to be true?
No, I don't.
Do you believe mental illness is real?
Yes, I do.
Okay. Would you be open to considering a not guilty by reason of insanity defense if it were proven to you by the defense?
If the evidence would, yes, I could.
Okay. I don't have any other questions, sir. Thank you.
Thank you, Mr. Williams. Ms. Miller, you may inquire.
Hello.
Oh,
Okay, just want to back up a little bit and ask you a few follow-up questions, okay?
yes.
We all know what you mean. It's this lovely lady who writes everything down. It just doesn't translate.
No, that's fine. I understand. Sorry.
Premeditated first-degree murder is defined as the intentional killing of another human being. That defendant thought about it, meant to do it, and did it. And if a jury finds that person guilty, that jury would have considered any defenses to the crime of first-degree murder, and by convicting him would have rejected those defenses. With me?
Yeah.
And so we are talking about someone who's committed intentional, premeditated killing of an innocent victim without any legal justification, excuse, or defense. For you, is death the automatic penalty once you've determined that someone's guilty of that crime?
Objection.
Rephrase.
Do you understand?
I'm going to overrule. He can answer that question.
Sorry, you can. Should we back up?
Yes.
You can answer that one, but the general question is, I'm trying to make sure we're on the same page as to what first-degree murder is, right? So it's the intentional, premeditated killing of an innocent victim without legal justification, excuse, or defense. So is death, for you, the automatic penalty for someone once you've made the decision he or she is guilty of that crime?
No.
Why not?
I don't know. It depends on, I guess, the heinous nature of the crime. I mean, I don't know, it's kind of hard to explain. Different things, different circumstances. For me, I'm not going to automatically render somebody should be put to death just because they killed somebody. I mean, even though it was somewhat intentional or it was intentional, I can, if the evidence points to that process, but if it sways a little here and there, I mean, I can see somebody staying life in prison would not, I mean, they're giving up their freedom to do things that everybody else gets to do every day, so.
True. And I hear you, I agree with you. And I think most people feel that way, that this is a hard thing to articulate. But my next thing is I'm going to ask you to try your best to, answer out loud. Because I don't know you, and this is our only opportunity to speak. Right? And obviously this is a really important conversation we're having.
Yes.
Let me add an additional factor of this kind of hypothetical conversation we're having.
Okay.
If the innocent victim was a law enforcement officer, does death become the automatic penalty once you've decided the defendant is guilty of the intentional, not somewhat, intentional premeditated killing of a law enforcement officer?
Not really. I just, like I said earlier, it's a human being to me. It's whether they're wearing a uniform or not, everybody's entitled to, life.
Sure.
It could be you, me, anybody. The uniform is not a factor for me. I mean, I see people all the time. My brother served in the armed forces, and it's, things happen. Everybody has a job, everybody does what they do. Like I said, I respect law enforcement, love them to death. These guys do, and men and women do a great job for us, but at the end of the day, everybody puts their pants on one leg at a time, so.
Sure. And you can sort of appreciate why I'm asking this, that some people say, like the example about if the victim was under the age of 12. And some people say the same thing about police officers, right? Because they're entitled to that respect or deference from us.
Yes.
And so let me ask an additional question for you. If this defendant who is guilty of the intentional premeditated killing of a police officer has also been convicted of another intentional premeditated murder and is serving life in prison without the possibility of parole, does death become the automatic penalty for this murder, the intentional killing of a law enforcement officer?
To be honest with you, I mean, it sways a little bit, yeah, because you think in your mind he's taken 2 lives and with no malice or recourse on any of it. So you tend to drift that way. I mean, for me to say honestly and 100% yes, that's what I would think, I can't say that. I don't think like that.
Okay, I hear you. And I think that most of us think in some shade of gray, right? Would it be fair to say for that person who's guilty of the intentional premeditated killing of a law enforcement officer who's already been convicted of another murder, intentional murder, that your starting point is death, and then either myself or my colleagues have to do something to convince you why life is the appropriate penalty for that person?
Objection.
I'll allow that question. Go ahead.
You can answer that one.
I wouldn't be swayed either way on that. I mean, I try to believe I'm a free thinker. I can, see things that are, right from wrong, left is right, the whole 9 yards. And for me to sit here and tell you that would be automatic, no, I can't.
I hear you. What I'm asking is, do you think you're like, okay, I go into this process, if I know that this person is guilty of the intentional premeditated killing of a police officer and is already serving life for another murder, my starting sentence in that scenario is the death penalty. And then I'll listen, but either me or one of my colleagues is going to have to convince you why life is the appropriate penalty.
If I hear a reasonable, response to why he shouldn't be put to death, I mean, I'm an open-minded person. I could see myself saying life is what should be, but again, I have to hear it all, so.
Sure. What I'm really getting at is death where you start. Is the death penalty where you start for that person?
No, it's not where I start. I don't start with just death. It's, like I said, I'd have to weigh all the thinking in my mind is everybody's presumed innocent until proven guilty. That's just the way I was always brought up. And it's just something it's hard to describe. It's just the way I think. I can't say, no, that's automatic, he's getting, I can't do that.
Right. I hear you. I just want to make sure we're on the same page. I agree with you. Everyone should be presumed innocent. But if we're at the part where we're deciding the appropriate penalty, as a jury, you've already made a determination that person is guilty without any legal justification, excuse, or defense. Does that make sense?
Yeah.
Right? Like, we're not talking about life or death if the person's not guilty of first-degree murder. Right? And so what I'm trying to figure out is, for some people, they say, listen, once I've decided someone's guilty of first-degree murder, really the only penalty is the death penalty. And I'm not hearing you say that.
No.
Okay? But we've now added that the victim, the innocent victim of the intentional killing, is a law enforcement officer, and this defendant is serving a life sentence for another murder. And so I'm trying to figure out if we're in the second part, if your starting penalty is the death penalty for that person under those circumstances.
Objection asked and answered.
Sustained.
You talked about the circumstances of the crime and you used the word heinous. Is that correct?
Yes.
Tell me what that means to you, please.
I guess what ruling nature it was, done by, I guess the example would be is if somebody had done something and they had the opportunity to get away, instead came back and did something more brass, like, say, it's hard to describe.
Doing great.
So, like, somebody got shot, that person could just get away because that person's incapacitated, can't move, can't do anything, can't chase, can't do that. But then they came back and they, so to speak, finished the job, just did the unthinkable by ending somebody's life because they just either had no malice to their thinking or they just wanted to shut them up, make sure there was no witness. No.
Okay. May I have actually just one sec, Judge?
You may.
Witness elimination is an aggravator, correct? You sure? Is EAC an aggravator? Could somebody? In the scenario you just described, would death be the only penalty really at that point?
Yeah, probably. I would say yes. I can't honestly say no.
And I think we've all kind of said this in a different way. You understand death is never required, not in any case, not in this case, not in the worst imaginable case you could conceive of.
Yes.
And unsurprisingly, 12 people are expected to have differences of opinion about whether someone lives or dies. The law contemplates that.
Yes.
If one person decides that life should be the verdict, then life will be the verdict. Are you okay with that?
Yes, I'm okay with that. I mean, they're entitled to their opinion, and sometimes people like to try to sway other people. And I mean, if you have your mind made up that you believe that person belongs in jail for life, who am I to sit here and browbeat you to try to change it? I mean, we all have feelings and we all have opinions, so everybody's a free thinker. So.
You are anticipating where I'm going. Not that you can tell, because you are 100% anticipating what I'm about to say, and that sometimes things get contentious in the deliberation room.
Yeah.
And the law says that in order for a just verdict to be returned as to life or death, all 12 jurors' individual moral assessments have to be heard in this courtroom. And it sounds like you're good with that.
Yes.
Okay? And we talk about mitigation, and that's a legal term that literally means why one person or any people decide to give life or not give death. And it doesn't have to be unanimous. Each juror can decide what is mitigating to that juror. And it could even be something seemingly small, like a smile observed between the defendant and a family member. And that juror says, that was mitigating to me, and I'm going to assign that the weight of life. Is that okay?
Yeah.
Yeah?
Yes.
Okay. You're not going to bully or badger anybody to agree with you, correct?
Yes, I'm not going to.
And you wouldn't allow anybody else to bully or badger sort of on your watch back there?
No, I would not. That's not, like I said, everybody's entitled to their opinions, and I just don't think that's right. It's not like everybody has issues with life in general, so they're going to have problems, and if somebody strongly believes in something, there's not really a lot you can do to change their mind. I mean, it's just the way they think. So respect that. That's what I do. I respect that.
Thank you, sir. May I have another moment, Judge? I have no further questions. I do have a motion.
All right, let me see the attorneys at the bench. We'll be right with you, sir.
Notice to seek aggravator. You're supposed to tell me.
All right, sir, are you ready? We appreciate the time and attention that you've given us. You've been really great this morning. I'm going to excuse you as a juror in this case. You're free to get on with your life. Thank you very much.
Thank you.
Thanks.
Panel.
Juror in seat 33, please. Good morning, how are you?
Not too bad. Yourself?
I'm doing okay. We're going to ask you a few questions. There aren't any right answers to these questions or wrong answers. What we need to know is what you actually believe, what you actually think. So please just answer the question openly and honestly, and don't worry about what the answer is, okay? I'm going to start, and then the attorneys may have some questions for you. Let me start with, you indicated that you had some knowledge of this case, is that correct?
I remember the case from a little bit ago, but I didn't know any specifics until you brung it up again. It kind of rung a bell there.
Okay, so what do you remember about what you heard? Not what I told you, but what you heard.
I remember that it was a murder case, but like I said, it was very vague. I didn't remember much.
Do you watch a lot of local news?
Almost none.
Where do you normally get your news from?
Social media.
Social media? Did you read anything on social media about this case?
Never.
Okay. Based on what you heard, did you form any opinion as to whether or not Mr. Loyd was guilty?
No.
Do you have any personal, moral, or religious objections to the death penalty?
I do not.
Are you a person who believes that if someone is convicted of first-degree murder, intentionally killing another person, that that person should automatically be sentenced to death?
Not automatically.
Okay. If that person is a law enforcement officer, do you believe that death should be an automatic sentence?
I would say yes.
You would say what?
Yes.
Okay. You understand that in the state of Florida, death is not automatic for anybody, including the death of a law enforcement officer. You have to be able to fairly, with an open mind, listen to both sides about what the appropriate penalty is. And it doesn't mean sitting there thinking, okay, I'll listen to you talk, and then I'm going to go back there and vote death. That's not what an open mind means, all right? And like I said, just be honest with us. Do you think that you could, if there was a conviction for first-degree murder in this case, it would be of a law enforcement officer? So do you believe that you would be able to listen to the defense's mitigation with an open mind, or would you be thinking he needs to be sentenced to death?
I would look at the facts. I would not be presumptuous about it.
Okay. So you can put aside your personal opinion?
Yes.
And if after you heard everything, the way this works is the state has to prove at least one aggravator beyond a reasonable doubt. If they don't, there is no death penalty, even a possibility, okay? It's life. But let's say that they did. Now the defense is going to put on mitigation, reasons that life would be the appropriate sentence. So could you sit there and listen to it with an open mind and then go back there and weigh it, assign whatever importance you have personally to the aggravators versus the mitigators, weigh all of that out, and if you believe that the appropriate sentence was life without the possibility of parole, could you vote for that?
I could.
Even if it was a police officer?
Yes. Yes.
And if you believed it was death, could you vote for that?
I could as well.
All right. During the guilt phase, where you're trying to decide whether or not Mr. Loyd is guilty, he's raised the defense of insanity. The burden is on the defense that time. It's the only time the burden's on the defense in the guilt phase to prove by clear and convincing evidence that he was insane. So if at the end of that case, you've heard all the evidence from the state and the defense, you believed he was insane, would you be able to return a verdict of not guilty by reason of insanity?
I could.
And remember, I told you that he's been previously convicted of the murder of Miss Dixon and her unborn child, and he was sentenced to life without parole. You can't use that to determine whether or not he's guilty of these charges. You have to put it completely out of your mind. Could you do that?
I could.
And would you automatically vote for death because he'd been previously convicted of murder?
No, two separate things.
All right, you just listened to everything that was told to you? All right, thank you, sir. I don't have any other questions for you. State, you may inquire.
Jared Tillman.
Hold on. The state's going to inquire now.
Oh, my
All
bad. Sorry.
No
She
problem.
was just telling me it was time for me to stand up, that's all. How are you, sir?
Not too bad.
Would you say that you're in favor of the death penalty?
I wouldn't sway either way. I believe that it can be a possibility depending on the case.
Okay. And every now and then I have to stop and take notes on what you say because I can't remember it all, so forgive me for doing that.
Of course.
I'd like to explore the aspect of this case that involves a law enforcement officer, okay? Going back to what the judge first described, because we're going to mostly talk about what your views are as to what a sentence should be. So, to remind you, that phase 2 of this proceeding would only begin if the jury unanimously convicted Mr. Loyd of first-degree murder, right?
Yes.
And I'm not trying to talk down to you. I want to make sure that you understand the process and your role in it. So if that were to happen, in Florida, there's only 2 potential penalties for first-degree murder: life without parole or a sentence of death. Make sense?
Yes.
So in order for a sentence of death to be a possibility, to use your words, certain steps have to be taken and facts found. The first thing that would have to be done is we would have to present evidence of aggravating factors to you. And those are things like involve the circumstances of the crime, potential sensitivities of the victim, or things about Mr. Loyd's background even, that our legislature has said make this particular first-degree murder above and beyond one that lacks those aggravators. And that's what makes it eligible. By way of example, one of the aggravators in Florida is that the victim was a child under 12. Right? Our legislature has said if that is the case and the state proves it beyond a reasonable doubt, then that is an aggravating factor that could potentially warrant a sentence of death. Does that make sense?
Yes, it does.
So if and only if the jurors unanimously made a finding that at least one aggravator was proven beyond a reasonable doubt, then the defense would present evidence of mitigating circumstances, and that's anything about Mr. Loyd's life, background, or experience that are reasons they believe Mr. Loyd should not receive a sentence of death and that life without parole is appropriate. It could be something like he experienced racism during his life. Make sense?
Yes.
And you would be obligated to listen to those mitigating circumstances before making a decision on the ultimate decision of what a sentence should be. My first question for you is, do you think you could withhold judgment and give meaningful consideration to those mitigating circumstances before reaching a decision?
I definitely could.
Would it be important for you to give that information, or would it to listen to that information, or do you think it wouldn't be that important?
I think and it's definitely helpful.
And why would it be helpful to you?
Because just going off of the mitigation and the other
Aggravation.
one, and aggravation, if you just went off the aggravation, you wouldn't know, it wouldn't be too black and white. You wouldn't be more in depth.
Okay, so more in depth, you'd want to hear more information from both sides.
Yes.
Okay. So now I told you I wanted to ask you about the law enforcement aspect, and it took me a while to get there. But do you have some, I'm going to use the word sensitivity or certain respect for law enforcement? Is that what was driving your earlier decision?
I do.
Okay. So I want you to imagine a circumstance where you heard not only that the victim was a law enforcement officer, but that the defendant stood over her and shot her intentionally multiple times, purposely to end her life because she's a law enforcement officer. You with me?
Yes.
Would you think that's pretty egregious?
I would.
Could you still, even if you heard that, give meaningful consideration to the mitigating circumstances? Or would those set of circumstances inflame you to the point where death would be automatic for you?
It would make it harder, but I would still put into consideration.
Okay. Even being swayed by those circumstances, you would still give meaningful consideration to the mitigating?
Yes.
Okay. I want to ask you about the insanity defense by way of asking you if you or anyone close to you has ever dealt with mental illness that you're aware of.
My sister has some. Some, yes.
Okay. Without telling me what it is, are you familiar with what the specific diagnosis is and her treatment, if any?
Yes, she sees a therapist.
Okay. So, given that, do you believe that mental illness is a real thing?
I do.
Given that you believe mental illness is a real thing, could you find Mr. Loyd not guilty by reason of insanity if it were proven to you by the defense as required by law?
If it was proven, yes.
Okay. And there was like a slight hesitation there. Tell me what your sort of slow answer, what that meant, what was going through your mind when you said that.
If he was possibly diagnosed in the past or other situationals that I may not know of yet, I guess you would say.
So you're referring to what the proof would need to be?
Yes.
Okay, understood. Can you think of any set of circumstances that could be proven to you? In fact, the judge even asked you, if it were proven to you not only that the victim was a law enforcement officer who was shot while on the ground, but that Mr. Loyd had been convicted of a prior murder, would you still be able to give meaningful consideration to any mitigation you heard?
I would.
That's all I have, Judge. Thank you. Thank you, sir.
Thank you. You may inquire, Ms. Miller.
Hello. When Judge Marquez first asked you if the murder, intentional premeditated killing of an innocent victim involved an innocent law enforcement officer, and she asked you, would death be the automatic penalty once you've made that determination, you said, I would say yes. Is that correct?
Yes.
Tell me what was going through your head when you said that, please.
Based off of the question in my respect for the law enforcement, it would be the first thought, but not the only, I guess you could say.
Say that last part again, I'm sorry?
It would be my first thought, but not that I wouldn't put anything in.
Okay. And that's where it's tough to sort of look inside and say, would this be something I'd give meaningful consideration to, right? And so I could tell you, hey, I'm asking you to go give meaningful consideration to sitting on I-4 in the middle of rush hour traffic. And you could say, sure, I would give that meaningful consideration, but it's not something you're really going to consider doing. And so I'm asking you, do you think if you have made the determination, and only you know this, right? And there really are no right or wrong answers, we're just looking for your truth.
Of course.
That once you have made the determination that a defendant is guilty of the intentional, premeditated killing of a law enforcement officer without any legal justification, excuse, or defense, is death the automatic penalty for that person?
It's a tough one for me.
Okay. You hesitated. Is that fair?
So yes, it would be a tough one. I would, depending on the facts again and circumstances and mitigations, to consideration though.
Would it be fair to say your starting point for somebody who is guilty of the intentional premeditated killing of a law enforcement officer is the death penalty?
Yeah.
And then either myself or a colleague is going to have to convince you as to why life would be a consideration?
Yes, exactly.
Let me see
Okay.
the attorneys at the bench, please. All right, sir, we appreciate the time and attention and your willingness to serve greatly. I don't think this is the case for you, given that it's a law enforcement officer, so thank you very much. You are free to go.
Thank you.
Thanks. Juror in seat 35.
Your Honor.
Good morning. How are you?
Good morning. At the appropriate time, at a conflict with you?
Yes, sir. Go ahead.
My wife and I have been pursuing the purchase of a home, and we were notified on Friday that the process of selling the house, it's been in an estate, will happen starting this week. It's going to be an interactive process. There are multiple parties who are interested in the property, and therein lies my conflict.
Okay. When you say it's an interactive process, I assume you and your wife are bidding on this house?
Yes.
And so you're expecting, is it all this week that the bidding is going to go on?
This week, potentially next week. We will do a fast close if we're fortunate enough to
get the house?
To get the house. So it's the ultimate bad time.
All right, do you think you would be distracted by that if you were asked to be a juror in this case, that you'd be sitting there thinking, I really need to be bidding on this house?
Yes, and I suspect that we would fail to get the house.
Okay. So let me ask you a couple more questions. I appreciate you letting me know this.
70 years old.
Oh, are you 70 years old, sir?
Yes.
You're entitled to be excused if you request it. Would you like to be excused?
For this circumstance only.
I appreciate that. You're free to go. Thank you very much. Juror in seat 39.
Thank you.
Good morning. How are you?
Good morning.
Good, thank you. We have a few questions for you.
Yes, ma'am.
There aren't any magic answers. There are no right or wrong answers. We need to know what you actually believe and think. All right, so just be honest with us
Yes,
in
ma'am.
answering the question. I'm going to start, and then the lawyers might have some questions for you. Let me start with, you indicated you knew something about this case. How did you hear about the case?
When it was on TV.
So do you often watch the local news?
Very rarely, because I usually travel Monday through Friday, so I mean, I very rarely get a chance to watch the news.
You just happened to be watching when this happened?
I happened to be on vacation that week that it all happened, so I was able to be home.
Okay. How much did you watch?
To be honest with you, not a whole lot. I mean, I did catch bits and pieces of what was happening and what was going on, but I didn't catch the whole full story.
Can you tell me what you remember seeing?
I remember seeing the situation at the Walmart when it was going on, and all the police activity when it was happening, and what was being talked about, and like I said, I mean, and then I was in and out, so I mean, that's really about all I remember.
Okay. Did you form any opinion as to whether or not Mr. Loyd was guilty at that time?
I did not, because there's two sides of the story. I mean, I wasn't there, I wasn't on scene, so I mean, who knows what happened? So no, ma'am, not to be honest with you, no.
Okay. Do you have any personal, moral, or religious objections to the death penalty?
No, ma'am.
Are you someone who believes that if someone is convicted of first-degree murder, the intentional killing of another person, that they should automatically be sentenced to death?
Not automatically, no, ma'am.
Okay, you hesitated for a second, so tell me what your thoughts are about intentional first-degree murder and the death penalty.
I'm sorry, can you say that again?
Sure. Can you tell me what your thoughts are about someone who's convicted of intentional first-degree murder and the death penalty?
The death penalty, I believe, is in my opinion, I believe it should be, like you pointed out earlier, it should be within beyond reasonable doubt that that happened. And until you hear both sides of the story, I don't believe that that should be automatically put on somebody, because we don't. I mean, us as civilians. I mean, we're all civilians, but us as people in everyday life, I wasn't there. I don't know what happened. So, I would like to hear, what both sides of the story has to say about it, and then come to an opinion after that.
Okay, so let me present you with this. In order to even get to a penalty phase where you're considering whether or not you want to vote for life without parole or death, you have to have found that someone committed first-degree murder you have to have made that finding beyond a reasonable doubt. So the person's been convicted, and it means that there's no defense that's been raised that you believe was true, that you found to be compelling. You listened to the state, you listened to the defense, and you convicted them of first-degree murder, the intentional killing of another person without justification, and you convicted them beyond a reasonable doubt. You with me so far?
Yes, ma'am.
All right. So my question is that for you the point at which you say, okay, now my vote is the death penalty?
Yes, ma'am.
Okay. Can you, and let me add to that, in this case it would be of a law enforcement officer. Does that make it more a death penalty case to you, or would you automatically, strike that last question, would you automatically vote for death in the death of a law enforcement officer?
No, ma'am.
No? Okay. If you were convinced beyond a reasonable doubt that the person was guilty, because it sounds like you're telling me two different things, and that's because this stuff is very convoluted. So you said, if you convict someone of first-degree murder beyond a reasonable doubt, intentionally killing another person without justification, you would vote for death. Is that
Yes,
correct?
ma'am. Yes.
All right. Would you even be able to consider life?
Yes, ma'am.
You could?
Yes.
All right. Can you explain that to me?
Well, because given the penalty between death and and life imprisonment, I don't want to do this without digging myself in a hole.
Remember what I told you. There's no right or wrong answers. We just need to know what you actually believe.
Life imprisonment. You get that opportunity. I don't know how to answer that. Death penalty, yes. Like you said, if you were, if it was proven and it's down to a T that you committed murder, like you said, in first degree, and it was and there was no other way around it, then yes, then the death penalty ought to be given out. But if you have the opportunity to where there's that shadow, maybe it wasn't. He doesn't, or the person doesn't deserve death. Then we need to look at, okay, then what does he? What's the next possibility after that of being able to live out the sentence and think about what had happened?
Okay. As I told you, death is not an automatic sentence for convictions on intentional first-degree murder. Even if you intentionally kill a child in the state of Florida, there is no automatic death penalty.
Yes, ma'am.
There's a penalty phase, and at that penalty phase, you start with the state presents their aggravating factors. They must prove at least one beyond a reasonable doubt for the death penalty to even be a possibility. With me so far?
Yes, ma'am.
If I lose you, let me know. Okay?
No, I'm with you.
The defense then presents mitigation. Those are reasons they believe the vote should be for life without the possibility of parole. In order to do your job as a juror, and you have to be able to listen to both with a completely open mind, all right?
Yes, ma'am.
Meaning you can't sit there with your arms crossed saying, okay, they can talk, but I'm not really listening to this. I'm just waiting until I can get back there and vote for whatever I want to vote for, okay?
Yes, ma'am.
So once you get back in that jury room, I'll give you some instructions on how to do this, written instructions on the law and how you do this. But basically, as I told you, you're going to weigh those aggravators the state presented and the mitigation that the defense presented. You can assign to each of those aggravators and mitigators whatever importance you personally give them. It's an individual decision for each juror. You might hear a mitigator that you say, that's really important to me. I think that's very compelling and something that I really want to focus on. You might hear an aggravator and go, I'm not interested in that. Or you might say, that's very compelling to me. So in the end, you have to weigh that and make a decision. So in a case when it's the murder of a law enforcement officer, can you weigh those two things out fairly and equally? And if you believed that the sentence should be life without the possibility of parole, could you vote for life without the possibility of parole?
Yes, ma'am.
And if you believe death was the appropriate sentence, could you vote for death?
Yes, ma'am.
Would you be automatically going one way or the other before you'd heard anything?
No, ma'am, like I
I mean,
mentioned.
once you've heard the evidence, it's different, but before you'd heard anything. All right. The defense of insanity. If Mr. Loyd's raised the defense of insanity, and that is the one time that the defense has a burden in the guilt phase, when you're trying to decide whether someone's guilty or not penalty. It's their burden to prove it by clear and convincing evidence. But let's say it's the end of the case, you've heard all the state's evidence, you've heard the defense's evidence, and you think he was insane at the time this happened. Would you be able to return a verdict of not guilty by reason of insanity?
Yes, ma'am.
All right. And then lastly, Mr. Loyd has been convicted of the murder of Miss Dixon and her unborn child. She was pregnant at the time, all right? He was sentenced to life without the possibility of parole. You cannot use that to decide he's guilty of these charges. You understand that?
Yes, ma'am, I do.
That's for later on in the trial. Can you put that out of your mind and hold everyone to their burdens in this case?
Yes, ma'am, I can.
All right. Thank you, sir. I don't have any other questions for you. Mr. Williams, you may inquire.
We don't have any questions, Your Honor.
All right. Thank you. Defense? Let's see the attorneys at the bench.
Yes, ma'am.
You said when the judge asked if a defendant is guilty, intentional, premeditated killing, victim, thought about it, meant to do it, and did it, with no justification, no legal justification, excuse, or defense, death was the automatic penalty, correct?
Yes, ma'am.
Okay. And then the judge asked you to elaborate, and that's what I just wanted to make sure I had the right information. You said the death penalty ought to be given out. But I mean, if you had the opportunity to where there's that shadow that says maybe it wasn't, and then you kind of trailed off and changed topics, is the shadow that you're talking about a shadow of doubt as to whether or not that person is guilty of the crime of first-degree murder?
I guess, well, I should have, I'm not going to try to backtrack. You're right on what I said. I guess I mean by that shadow, I mean like if, between the jurors and I mean, if there was that shadow, I mean, but it's already been proven. I mean, do we stick with that, the death penalty? That's what I meant by that. Not seeing like, do we give him the chance for parole? Do we stick with the death penalty automatically because of what has already been proven?
All right, let me intervene here, sir. There is no parole in the state of Florida. Life without the possibility of parole.
Yes.
Defendant dies in prison. You understand that?
Yes, ma'am, I do.
Okay.
I'm sorry, I said the wrong thing.
It's all right. This is a strange situation for you. I understand. Go ahead.
You're doing fine. We're just looking for what your truth is. Right? There are no right or wrong answers. Would it be fair to say, once you've determined that someone is guilty of the intentional premeditated killing of an innocent victim, that your starting penalty is the death penalty?
Yes, ma'am.
And then either myself or one of my colleagues is going to have to convince you why life might be appropriate.
Yes, ma'am.
Okay. And so that's what then...
Let me see the attorneys at the bench. Thanks. All right, sir. I appreciate your willingness to serve and your being here very much. We all do. I don't think this is the case for you for a variety of reasons. So we're going to excuse you from this case with our thanks for being here. You're free to go.
Thank you.
Thank you. All right, I'm going to do one more before we break for lunch, which is let's bring in juror in seat 48 and send the rest of them to lunch. Returning here, they need to be back by 1:30, please. Yes, thanks.
This juror was the one that had the vacation from the 24th to the 26th, is that correct? That's coming in?
Yes. Why didn't we, wait, hold her there for a second. Why didn't we excuse her for the vacation? Can anyone remember?
We believe we missed it.
So can we go ahead and excuse her? And then I can do 49, state? I do have a note that she has a vacation from October 24th to 26th. It's juror number 185. She's in seat 48, panel 5.
We all have that note. The only thing I can remember is that we weren't sure if we would be done and started the trial by the 27th, which is next Wednesday. So the 24th to the 26th is Sunday, Monday, Tuesday. But we'll leave that in the court's discretion. She did say that.
Well, it's looking, see, I don't know.
I think this was the conversation we had.
Yeah, and I don't.
So October 24th and 26th.
Yeah, well, the thing is, it would be Monday, and Monday may be the day we're doing general voir dire that she's coming back. So I'm inclined to excuse her just because I don't need to add more uncertainty to the process.
We don't object, Judge.
Can you bring in 48 so I can excuse her, please? And then I'm going to call 49, and then everybody else can go to lunch. 49, 1:30 to return. We're having a short lunch today, and apparently a late dinner. 48. Good morning, ma'am. Well, it's afternoon now. Sorry.
Good morning.
Did you tell us that you have a vacation October 24th, 25th, and 26th?
Yes, that is correct.
So you'll be back on the 26th or the 27th?
I will be back the night of the 26th, the Tuesday. So I'll be available the 27th.
Okay.
I also learned that I have a work trip November 1st through the 5th.
You don't have to get into that. I'm
Okay.
sorry. We completely missed your vacation.
Oh,
I guess it's the number of people we've been talking to. We apologize. You're free to go.
okay.
Thank you.
you.
You're excused. Thanks. Good afternoon. How are you?
Good afternoon, Your Honor. I'm fine, thank you.
I have a few questions for you. Then the lawyers may have some questions for you. There aren't any magic answers. There's no right or wrong to these questions, all right? We need to know what you believe and what you think so that we can be sure that you can do your job as jurors in this case, all right? Sometimes jurors fit one case, but they don't fit another one. I'm going to start with this, which is, as we told you, the charge in this case is first-degree murder of a law enforcement officer. And I noticed that you are a former law enforcement officer. How long did you serve in Puerto Rico?
Well, I served in Puerto Rico for 18 years. I was a sergeant there. And after that, I moved to Texas. I'm working for Dallas Police Department for 2 years.
Texas.
Texas. And then I worked for the Tarrant County Sheriff. I was a deputy sheriff also for judicial.
Okay. So do you think you could be a fair and impartial juror in this case?
I believe I am.
Okay. And if Mr. Loyd was convicted of first-degree murder of a law enforcement officer, as I told you, there is no automatic death penalty in Florida, do you believe that you could fairly consider a life sentence without the possibility of parole?
I do.
All right. So you also said you knew something about this case. Can you tell me what that is?
I just read something, in the news when I came here to Florida in 2017, sorry. I moved from September, October, because I transferred from Texas here for my job, and I see something on the news. But exactly what it is, I can't. But I remember something because it's a police officer involved, but honestly, I never read something or know nothing. It's just, I see it, I saw it.
All right. Did you form an opinion as to whether or not Mr. Loyd was guilty at that time?
Excuse me?
Did you form an opinion as to whether or not Mr. Loyd was guilty at that time?
No.
Was that a no?
No, I don't have any opinion, so.
Do you have any personal, moral, or religious objections to the death penalty?
No. No, ma'am.
Are you someone who believes that if a person is convicted of first-degree murder, the intentional killing of another person, and they're convicted of it, that they should automatically be sentenced to death?
Yes.
You do?
I do.
All right. How long have you held that belief?
How long?
Yeah. How long have you believed that?
I always believe that. So
You've always believed that?
It's on my person, yeah.
All right. In order to be able to follow Florida law and sit as a juror in this case, if Mr. Loyd was convicted of first-degree murder, you would have to be able to fairly consider life without the possibility of parole. Do you think you could do that, or would you be thinking, he's been convicted of first-degree murder, intentionally killing another person, I'm going to vote for death?
Yes, I can do it. I can.
Which one can you do?
Life in sentence or whatever the jury we make an agreement, but I can do life sentence without parole.
All right. Could you do a life sentence without a problem?
Yes.
Could you set aside your belief that once you're convicted of intentionally killing someone, you should be sentenced to death?
Yes, I can sentence to that too, yes. So it depends.
No, that isn't really what I'm asking you. Let me see if I can ask it a different way. You just told me that you believe that if you're convicted of killing someone, you set out to do it and you did it, you killed them, that you should be sentenced to death, that you've believed that for a long time. Is that true?
It's true.
All right. So in this case, in order to be a juror in this case, let's say Mr. Loyd's been convicted of first-degree murder, all right? The jury has found beyond a reasonable doubt that he intentionally set out to kill someone.
Yes.
Now you've got to listen to the penalty phase. The state's going to present aggravators, reasons they believe death is the appropriate sentence. The defense is going to present mitigators, reasons they believe life is the appropriate sentence. You have to be able to listen with an open mind. You can't have any preconceived notions about it. You have to listen to both sides fairly. Mm-hmm. Then you've got to go back there and weigh the aggravators and the mitigators based on the rules that I give you about how to do that. You can find one more important than the other to you. That's fine. Mm. But if all of that led you to believe that life without parole was the appropriate sentence, could you vote for life without parole? Or would you vote for death?
I can vote for that, yes.
Okay. All right. Any objections from state?
No, Your Honor.
Defense? All right. All right, sir. I don't think this is the case for you, but we appreciate your willingness to serve and your prior service. So you're free to go.
Thank you.
Thanks. I think I let everybody else go, didn't I? Yes. Okay. So lunch break. Be back. Get here before 1:30 so we can start back up at 1:30. We have 1, 2, 3, 4, 5, 6, 7, 8, 9. We have 10 jurors left to talk to. What? That's what I'm counting. 9? What? I have 4, 7, 16. Okay, so I have 16, 24, 28. Okay, 38. No, they were told to come back at 2 because they were late. 42 and 55. Oh, and 30. Is that what everybody else has? Left from this panel is 4, 7, 16, 24, which is coming back at 2. So is 7, 28, 30, 38, 55, and 42. Those are all the 9 o'clocks. All right, see everybody back at 1:30. Thanks. Court's in recess.